Melody Miller.
Thank you.
Ms. Parker.
Good morning, Your Honors. This case is here, having been reported by the lower court judge, to answer a question concerning personal jurisdiction, whether the Windsor case applies to the instant case or whether...
Are we concerned only with personal, or I know we're concerned with that, but is subject matter also an issue here?
Yes, because it's never waived, the husband is asserting that subject matter jurisdiction is an issue as well.
If the court has personal jurisdiction, I know that the two are different, but if in the circumstances of this case the court has personal jurisdiction over the husband, does the court have subject matter jurisdiction?
The husband contends there is not subject matter jurisdiction.
No, I understand that, but that's premised on his arguments of lack of personal jurisdiction.
Because the cause of divorce occurred outside of Massachusetts, is that why subject matter is missing?
Yes.
But that would also mean no personal
But I mean,
jurisdiction.
I understand your argument that subject matter jurisdiction is never waived, but subject matter jurisdiction was not reported to us, was it? It was only personal jurisdiction that is the subject of the judge's report.
So Your Honors have the choice of whether you want to hear argument on subject matter jurisdiction. I can focus just on personal jurisdiction.
Well, I mean, you will obviously focus on personal jurisdiction, but my question was, if in fact there's personal jurisdiction, because for personal jurisdiction the events have to have, the acts have to have occurred in Massachusetts, among others, that in this case, mutatis mutandis, confers subject matter jurisdiction. So why don't you address it as personal jurisdiction?
Okay, Your Honor. The wife, Naomi, filed a complaint for divorce, and in the alternative, a complaint for custody and support on February 14th, 2005, just to the day 6 months after she had arrived in Massachusetts. The complaint states that the parties were married at Princeton, New Jersey on June 18th, 1979, and last lived together at Tucson, Arizona on August 14th, 2004.
Yeah, you're going to give us now a recitation of why there aren't enough contacts, if I can use that word, in Massachusetts to create personal jurisdiction over Mr. Miller, right? I have a little trouble with the way this was handled procedurally by the judge. As I understand the way you treat these things, this was all done on papers, right?
Correct.
And there are affidavits, dueling affidavits. Practically everything is contested, is it not?
Correct.
And to decide whether there's personal jurisdiction, as I read the cases, the judge is supposed to distill out the uncontroverted facts and look only at those and decide if that confers jurisdiction. Am I right?
Correct.
And the burden of proving jurisdiction is on Mrs. Miller, right?
That's right.
So out of this whole mess that was presented to the judge, that wasn't done, was it?
No, it was not.
She
And
made
relied on
findings of fact, picking, what she thought was correct in certain affidavits and not correct in other affidavits. She made findings of credibility, which you're not supposed to do in the absence of an evidentiary hearing. So why doesn't this all have to go back for either a proper evidentiary hearing, or could it just be said the wife failed to meet her burden, and that's the end of that, or both?
Your Honor, I think that it can just be said that the wife failed to meet her burden because she cannot meet her burden under either Windsor or Unal. Windsor says maintaining a domicile in this Commonwealth the cause of action has to arise while the parties maintained a marital domicile in Massachusetts.
Now, but there was a very critical conversation that occurred, which, of course,
but
the wife
that's only
says,
relevant to the subject matter jurisdiction issue. Under the...
Parker, let me ask you this. We know we know that families, especially dual-career families, but there may be other reasons why somebody moves, typically in the course of a school year where they're minor children, one person will maintain the residence where they are because it's not favorable to sell, or they don't want to buy another place. In this case, it was Arizona, correct? Was it Arizona, where your client resides?
Yes, and
Okay.
for 15 years, the family resided there.
Right, and you know, the second spouse moves to a new place, is offered a job, decides to go. There's an agreement that they go. The person in Massachusetts acquires the new residence, is at the bank closing, signs the documents, and so on and so forth.
There was no home purchased in this case. Which
No,
doesn't-
well, that's even better.
You're-
I mean, is living here, and there may be 2 marital homes. This is not a voting case. This is 2 marital homes. Your assumption is there can only be one.
The case law says that, and domicile by definition is something that there's only in one place. Maintaining a domicile in the Commonwealth means the act had to. Let's take one step back to the statute. Under both statutory grounds, which we all agree that you have to have both a statutory basis under 222(3)A, and here it's 222(a)(G), subsection G.
And minimum
And
cost.
then you also have to meet the
Minimum
International
contest.
Shoe Fair Play.
Sure.
Well, here, both prongs of, the only 2 prongs available are not satisfied.
What I'm saying is, what is wrong with the judge's finding, even assuming that you get past Justice Glaney's question, that it should have been a hearing as opposed to affidavits, but I am assuming for purposes now that your respective clients would get up on the witness stand and testify to the same things, that in fact, for purposes of the domiciliary statute, the marital home was in Massachusetts. One spouse was here, the children were here, because the family, because 2 careers hadn't moved at the same
No,
time.
the trial judge found correctly that the husband never lost his domicile
But that's different.
in Arizona, and the marriage never changed domicile either. The husband never moved to Massachusetts. They maintained only one domicile, that was Arizona, and the wife left to Massachusetts. The husband never acquired the domicile in Massachusetts. Under 223(a)(G), the first prong says maintaining a domicile while a party to a personal or marital relationship out of which arises a claim for divorce. This has been stated as, in the Windsor case, as meaning that the cause of action for the divorce has to arise while the parties maintained a marital domicile in Massachusetts. Here, the judge correctly found that the parties had not maintained a marital domicile in Massachusetts. So under Windsor, there hadn't been any dispute. Under Windsor and prong number 1, there would be no personal jurisdiction over the husband in Massachusetts. Under prong number 2, the commission of any act giving rise to such a claim, there are a couple of cases, Unal and Rutledge, which fall within that prong. Both of these cases clearly state that you have to have the heft of the marriage in Massachusetts in order to do this.
So
the heft of the marriage here was in Arizona for 15 years.
If the cause of action arises in Massachusetts, even though the parties don't have, or one of them doesn't have a domicile, you need the heft in addition? Is that what you're saying?
Well, yes, you have to have the heft, because otherwise there's an interstate system.
What do you say about the judge's findings, in effect, that the cause of action occurred here? The irretrievable breakdown, that's a series of conversations. You know about those. November,
Yes.
December, and then finally December 23rd. Now, does he dispute that these conversations took place?
But aren't these conversations inadmissible?
The conversations are inadmissible as
Did you move to strike that part of the affidavit, saying they were barred?
It's a trial kind of evidentiary privilege that, and the lower court attorney, I was not the lower court attorney,
Well,
did
did
not
the lower
move-
court attorney make any motion to strike those portions of her affidavit?
Not to my knowledge.
Isn't it waived?
It's not waived because it's not waivable. It's not a privilege, it's a disqualification. Also,
Well, let's assume, get past that for a minute. Does he contest the substance of these conversations, that they occurred and what was
Yes.
said?
yes.
Yes, okay,
Yes,
so
he-
that's another reason why this has got to go back.
He says that the marriage had broken down in Arizona. In 2001, she was going off for long periods of time, not paying enough attention under his affidavits
The only
to the
act,
family.
yeah, the only act allegedly occurring in Massachusetts to cause the irretrievable breakdown are these conversations, is that right?
That appears to be
That's
it.
what the wife has asserted are the reasons.
Okay, and the conversations are either inadmissible because it's not a privilege, it's a disqualification, period. Husbands and wives can't testify against each other. Or it's a disputed fact,
Right.
one or the other. And that's the only act alleged to have occurred here to create the necessary jurisdiction. Is that right?
Yeah, for the purpose of irretrievable. Fixing that is the irretrievable moment when the husband had many earlier irretrievable moments when he begged her not to leave. He had a,
Ms. Parker, in a
Yes.
divorce, if you want to show, if it's contested and you want to show that the marriage is irretrievably break down, how can you not be permitted to say what your spouse said to you?
This is a statute. In Gallagher, this court said that it was for the legislature to change it. And despite this court not obviously criticizing the legislature's
Well, the
decision, it hasn't
disqualification,
been changed.
it clearly applies to marital proceedings. There's no exception for that.
Yeah,
There's
French
exceptions
versus
for
French
spousal
says
abuse
it
and all that kind of
applies to
stuff.
marital proceedings.
So if this goes back, we say, to the judge, you did this kind of the wrong way, hold an evidentiary hearing, he could quite properly assert the disqualification at that point, correct?
Correct.
And now she could testify the conversation that's occurred that led her to conclude it was irretrievably broken down. She could do that, correct?
Yes,
But she couldn't
totally
give she
self-serving.
couldn't give the words that were used.
Yes.
No, forget if they're self-serving. What you have here is he presumably is then not allowed to testify that she, she said that why she was going to Massachusetts, correct? So how do we know whether or not it broke down there or here? That's critical.
And it's
That is only relevant, however, to the subject matter jurisdiction issue, and
No,
not
it's
to the
not.
personal jurisdiction issue, because the heft of the marriage was in Arizona. For example, in the Rutledge case, the family had lived in Massachusetts, and the husband goes to live in New Hampshire, and he files for divorce and gets a property division in New Hampshire. The wife doesn't like the property division he got because she doesn't get the marital house, she just gets to stay in it until the kids graduate from high school, and she files in Massachusetts. And, of course, the husband tries to get the Massachusetts case dismissed, but the Massachusetts case refuses to give the New Hampshire case full faith and credit because the heft of the marriage had been in Massachusetts. So you have
In
to
that
have...
case, had the children moved with the father?
No.
Had
but
the
it's
wife moved to live with the had the wife moved to live with the husband?
No.
Had the wife engaged in marital relationships with the husband in New Hampshire?
It's not stated
that
in the
makes it a
case.
little different here.
It's not stated in the case. But also in Unol, the heft of the marriage has to have been in Massachusetts.
Well, the heft of the marriage may occur when, in fact, the parties haven't been living in two homes. It seems to me that what's problematic here, and it's not just to this case, it's going to arise in other circumstances. One party moves professionally ahead of another party. That in and of itself may put strain on the marriage. The second party, in this case the husband, may not have literally moved to become a domiciliary of Massachusetts, but there was a lot of marital engagement in Massachusetts.
He tried to reconcile, you could put it that way. He was unsuccessful. She moved to a place that was nearly impossible for him to move to. He has a very, very technical specialty. He requires a medical center, he would have had to go to Yale or Albany to get that level of medical center. He was a high-risk obstetrician. He would be having to commute hours and hours per day. So she moved to a place where she knew it was virtually impossible for him to find an appropriate employment.
And unfortunately, that's what happens in lots and lots of marriages when they're dual professionals.
She had tenure at the University of Arizona. She also had a sabbatical year coming, and he, in his affidavit, states that he was requesting that she use that sabbatical year to find a place that would be mutually agreeable, and that broke down, and she left. And the only things he did, he didn't help with the move. He was very attached to his children. There's a part in his affidavit that the hardest thing he ever had happen in his life was his children leaving him. So he came to see them.
Thank you, Ms. Parker. Ms. Booth?
May it please the Court. I'm Carol Booth. I represent Naomi Miller in this appeal, and with me is Linda Fidnick from our office. How
could the judge do what she did? She picked and chose among these affidavits that are utterly in conflict to say, here's what I find to be the correct facts, and here's who I believe to be credible. Can she do that?
Yes, Your Honor, she can.
Well, what do you do with the cases that say on an issue such as this, the judge is only supposed to look at, quote, the uncontroverted facts?
Well, I think for the issue of personal jurisdiction, the Cepeda case says that, in fact, the court can simply take in this case, Naomi's evidence about jurisdiction and find that she has made a prima facie case.
Oh, it does? Well, the Windsor case says the exact opposite, doesn't it?
No, Your Honor, I don't think it does.
It talks about uncontroverted facts. It doesn't talk about what you just said. Take the, complainant's evidence as true.
I think the problem in Windsor, Your Honor, was that the wife did not submit any facts at all. She didn't verify her complaint, and she didn't submit an affidavit. There was nothing on the record about where the marriage broke down or...
Was there a request by either party that there be an evidentiary hearing as opposed to submitting on affidavit?
I don't believe so. I think the court heard the motion to dismiss. It was, because there were affidavits, it was heard more or less as, I think, a motion for summary judgment on this issue, and she found the facts from the evidence that was submitted there.
How can you find the facts on a motion for summary judgment?
No, this is a motion.
Well, the attorney just said it was like a motion for summary judgment.
I think it was because the facts were as alleged in the two affidavits. I actually don't think...
But they were disputed.
Completely disputed.
With all due respect, I don't think the facts upon which the court relied were particularly disputed. The characterization of what happened was disputed.
What about the content of all these conversations, which appear to be inadmissible?
There is case law, Your Honor, that says if there's no objection, they are admitted for their full probative value. And as Your Honor pointed out, I don't think it was actually necessary for the court to take into account the content of the discussions, but rather that they took place, and as a result of those conversations...
Well, I don't understand your statement. That's in your brief, and I don't understand how can the fact of the conversations be of any use if you don't have the content of them. Just the statement that there were conversations. How does that affect anything if you don't know what was said?
Because the Caffin case says that the decision or the feeling that a marriage is irretrievably broken down is a subjective one. And it is her testimony that as a result of these conversations or a result of the way he was treating her or whatever it is that she felt subjectively...
I take it she can testify something to the following. We lived together in Arizona. I needed to seek new opportunities because my doctor had told me that I needed to be in a certain kind of place. With the agreement of my husband, she's not testifying to any conversation. We went looking. I moved up there. He came to visit. He saw the children. We engaged in marital relationships. We then had a conversation. As a consequence of that conversation, I knew for the first time that I had serious problems in my relationship. I did not know before that time I had serious problems in my relationship. We then engaged in further other conversations. The nature of those conversations was such that I was confirmed in my view that my marriage was on the rocks. There was no suggestion that I move back to Arizona. That was the first time that I knew that my husband entertained these views, and that's, in essence, is what you're saying the judge did here.
Absolutely.
Did he contest that those conversations ever took place?
That's not in the record that he ever objected to that
I
evidence at
didn't
all below.
I didn't say object to
I'm sorry.
them coming in, but did he say the conversations did not take place?
No.
No, Your Honor. I think that one of the crucial sort of frameworks that needs to be understood about this case is the change that happened in Chapter 223A, Section 3G in 1993. That change was made as a result of an investigation and a bill that was submitted to the House that was concerned the enforcement of child support. And one of the recommendations back from 1985 on this topic was that personal jurisdiction be expanded. And that was what the Department of Revenue brought to the House and said, let us have greater ability to bring out-of-state parents in to the Commonwealth to have the child support issues determined here. And so when Windsor happened, that case had, that bill had already been passed, but the Windsor case, I do not believe, stands for the proposition that counsel for Hugh Miller would have you take it to mean. One thing that every court that's addressed this issue has said is that every personal jurisdiction case really is fact-dependent. And in that case, the parties once lived in Massachusetts, moved to Florida, and never returned until the marriage had already broken down. The wife then came back to Massachusetts. The husband never showed up in the state, except many years later to see his daughter graduate. So at that point, the only time the breakdown of the marriage could have occurred was when both parties lived in Massachusetts long before.
No, the only time the breakdown could have occurred was in Florida.
I think that what the court was saying is, in order for Massachusetts to have jurisdiction, the breakdown of the marriage would have had to happen in Massachusetts.
Oh, I see. I thought you said it did happen. No.
Yeah. So they're saying,
which it
where
clearly
can we...
didn't on the record, because she went. They both moved to Florida, and she was pregnant in Florida. Correct.
That's right. And in any case, she didn't put in any evidence that it did break down in Massachusetts. When we get to a Kinchi Unal, the court says, the court directs us to understand Windsor in the light of that question, where did the marriage break down? It talks about Caffin and it talks about Windsor and says, that's the question we were looking at. Where did the marriage break down? Not where did the parties have to live at the time the marriage broke down.
So your point is it broke down for the final time in Northampton.
That's
Or
correct.
she says for the first time.
I don't
Correct?
think... Yes.
I mean, she says...
There's nothing on the record that indicates that there was any discussion of ever...
So
well, there's
if,
contrary evidence, because she says the reason why I had to move was for medical reasons.
so if
That's correct.
If he did not dispute that those conversations took place, without getting into the substance of them, then you think that's an uncontroverted fact that permits on a paper record the judge to conclude that the marriage did irretrievably break down in Massachusetts.
Yes, Your Honor.
Along the lines of what was suggested, we had conversations, and I knew at that point the marriage was finished.
That's correct. And that is really the
That
only...
coupled with all this other stuff about, selling the home, coming up to visit, interviewing at Bay State, Springfield, Albany.
Having
so on.
conversations with third
Having
parties.
conversations
I'm
with
looking
third
for a job.
parties. Yeah, selling the stuff off so they could, the furniture and all that, so they could move. That's enough to create the heft that we
Absolutely.
need.
There was very little left in Arizona by the time this happened. And I actually believe that counsel for Dr. Miller has misunderstood the Rutledge case, because in that case, in fact, the Massachusetts court found that it did have jurisdiction over the husband who had lived in New Hampshire for many, many years, because the wife and children
Ms.
were
Booth,
here.
let me ask you this.
Yes.
This is a very seasoned probate and family court judge, and she says these cases are in conflict. You were at the hearing and you participated in the examination. Were you at the hearing?
No,
Okay.
I was
You've
not.
looked at the transcripts?
But I certainly have read the
Okay.
record.
Help me understand what it was, if you can, what the trial judge, who after all is trying to follow the guidance of appellate courts, was concerned about. Was it the heft of the marriage?
I don't believe so. That language is nowhere in her findings. And I think the language in Windsor that she is concerned about is the language that makes it appear that the marriage would have had to break down while both parties resided in
Correct.
in Massachusetts, and both parties, she found, did not reside there. I think her definition of domicile is too narrow in this case. I think if you...
But in any event, you can have a marriage with two people living in two different states,
Yes.
and so the court is, so that to have that as a necessary prerequisite that they have to live together in order for it to break down, you're saying is where she misunderstood the holding of Windsor.
Not that they had to live together in order for the marriage to break down, but that both parties had to live together in Massachusetts when it did break down.
Okay.
I assume they could have had separate Massachusetts residences, and it could still break down.
Okay.
So it was the fact that she found or she read this Windsor language to mean that, whereas I believe that if you look at the facts of Windsor, that is not the interpretation. And if you look at what the court said in Akinci Unal about what it was doing in Windsor,
Yeah, I
you
mean,
need to-
Akinci seems to distinguish Windsor in a reasonable way, a conscientious way. So the two of them can fit together.
I agree, Your Honor, although I think that if you just read that one sentence out of Windsor that says, well, if
Well,
she...
I read her findings and conclusions quite carefully, and she summarizes in paragraph 92 the Windsor facts. I don't think those facts are, her summary of the facts is inaccurate. And then she notes that the appeals court ruled that there was no long-arm jurisdiction over the husband, and that she said, given that reading, it appears that she couldn't assert long-arm jurisdiction, and I just couldn't get from paragraph 92 to 94, and I was trying to understand if you could close, and you think it's that point.
I think that she saw the issue as a question of when did the couple need to reside in Massachusetts? What was the relationship between residing in Massachusetts and the breakdown of the marriage? And before the change in 1993, there was a restriction. The couple had to live one out of the previous 2 years in the Commonwealth in order to take advantage of this part of the long-arm jurisdiction statute. That was eliminated, and that would appear to open the door and say, as long as the couple at one time resided as a married couple in Massachusetts, that part is satisfied. It doesn't have to be recent, doesn't have to be within any time frame. But the language in Windsor that I believe she's quoted, it's saying that in that case, jurisdiction could be conferred over a non-resident husband only if the wife could demonstrate that the cause of action of the 1994 divorce arose while the parties maintained a marital domicile in Massachusetts. That language makes it appear to say that you have to have a domicile in Massachusetts at the time the marriage breaks down.
Ms. Booth, can I ask you this? Did the husband contest that he and his wife had jointly looked for houses in Massachusetts?
Did he contest? I don't think there was a specific fact. His claim was that the marriage broke down in
No, I understand.
Arizona,
I'm just
so
looking at
I assume
the
that
facts.
that sort of encompasses that.
Did he contest that they had jointly selected schools for their children?
I don't believe so.
Did he
Well,
contest?
can I
Can he contest that after that the entire family went off to Europe on a vacation?
No, he did not contest that. And I don't think that the things that happened afterwards, I don't think there's one thing that happened afterwards that supports his contention that the marriage broke down before Arizona.
Can I ask a question about the
Yes.
school? There's
Yes.
something in the record about his signature having been forged on certain papers. What's that all about?
I have no idea.
School papers, in fact. Something.
It was an allegation that came up in the.
I thought the argument of the husband was, of course, he's going to sign the papers because, he's a loving father, which that's not in dispute.
That's fine, Your Honor, but that doesn't explain why he also signed for a joint bank account with Naomi after the move, that he also signed for a safe deposit box with Naomi after the move, that he registered his cars in Massachusetts after the move. He arrived here 7 days after she did to help her move in, to get things set up, to sign all these documents, and to move forward with what was then a joint plan to reside in Massachusetts. I don't think that those facts are not contested, and I think they can only lead to one conclusion.
Thank you, Ms. Booth.
Thank you.
We'll take a short break.
All rise.